Good morning. This is Mohammad Suleiman, Assistant Professor of Commerce, working at MVS Government Degree College, Autonomous, Mehboob Nagar. Today, let us learn about rights of unpaid seller. As all of us know that in a sale transaction, price is an essential requirement, wherein the buyer is supposed to pay the price and the seller, after receiving the price, will hand over the goods or commodity to the buyer. In some cases, it may happen that there may be some arrangement of payment at a later date or some conditional payment like payment in installments or payment at a later date and so on. So, in such a case, when the seller is not or seller has not received the price in full, in such a case, that seller is called an unpaid seller. So, in case the seller is unpaid, let us see what are the rights available to unpaid seller. So, the objectives of today's lesson are we will be learning about unpaid seller and we will be seeing about rights of unpaid seller and what type of different rights that he has, that is right against the goods and right of unpaid seller against the buyer personally, and consequences of breach of contract of sale in case of breach. So let us move on one by one and let us see about the rights of an unpaid seller. So roughly when we talk about unpaid seller, so different people may have different meanings of an unpaid seller, but in general, unpaid seller is the one who has not received any portion of the price. Maybe it is a small portion, maybe it is a large portion, maybe it is a substantial portion, but whatever may be the quantum, if something is due, if something is not received, then in such a case, the seller is called unpaid seller. When the whole price has been paid by the buyer, then he is no more called as an unpaid seller. Therefore, it can be understood or it can be concluded that if any portion of the price is due or if some portion of the price is due, then the seller is called an unpaid seller. Now let us see the definition of unpaid seller given according to the Indian Contract Act. Section 45 of Indian Contract Act lays down that unpaid seller is that a seller is unpaid when the whole of the price has not been paid or tendered. For example, if a person agreed to purchase a refrigerator for rupees 20,000, let us assume if 5,000 is due out of rupees 20,000, then 5,000 will come roughly about 25% of the agreed commodity or good. But in this case, because the 25% amount has not been paid, the seller is called unpaid. Therefore, Section 75 lays down that a seller is unpaid when the whole of the price has not been paid or tendered. And in some cases, what may happen? A negotiable instrument or a bill of exchange may be given in the form of payment. So, in such a case, when a negotiable instrument or a bill of exchange has been received as conditional payment and the condition on which it was received has not been fulfilled by the reason of the dishonor of the instrument or otherwise. Let us take a person purchases a good or purchases a durable good like washing machine. If he gives a negotiable instrument, let us assume a check, he has given a crossed check in the name of the firm directing to pay some amount to the firm on purchase of the washing machine. If the check given by the consumer is dishonored by the bank due to some reason, then in such a case because the negotiable instrument is dishonored, then the seller is called as unpaid seller. Let us take one more example. On purchase of some commodity or good from one seller, a person gives a bill of exchange as a conditional payment order for a period of 30 days. If on the date of on 30th day, if the seller produces the bill of exchange for payment, if it is dishonored, then in such a case, the seller is called unpaid seller and the whole or some of the portion of the price is not received. Therefore, in such a case, according to section 45 of the Indian Contract Act, the seller becomes an unpaid seller. Therefore, it can be assumed that the seller remains unpaid so long as the portion of the price is remaining unpaid, however it is small or big. And in some cases, if the whole of the price has been tendered and the seller refused to accept such a tender, the seller ceases to be an unpaid seller. He is no more called a unpaid seller. In such a case, the seller loses all his rights against the goods and all rights will be with the buyer only. In some situations, it may happen that some credit is given. If there is a period of credit, then the seller is not unpaid until the price becomes due. If the price is supposed to be paid on 5th of every month, on 5th of every month only the seller is unpaid, but not before the 5th. And the condition to this payment shall be fulfilled to say that he is an unpaid seller, and the right of an unpaid seller can be exercised by him or his authorized agent to whom he has given some authority to exchange his rights. Therefore, unpaid seller is a person to whom some portion of price is due. So, having discussed about the unpaid seller, let us move on to talking about rights of the unpaid seller. The Sale of Goods Act provides two types of rights to an unpaid seller, and those two types of rights are on two different dimensions. One is against the goods, and second one is against the buyer personally, because it is the buyer who involves in buying and it is the goods which is being exchanged between the buyer and seller. Therefore, the Sale of Goods Act provides the rights on both these two, that is the goods and the buyer personally. Against the goods, the rights of an unpaid seller are when the goods or the property has been passed in one situation, and in some cases when the property has not been passed. That means when the goods are handed over to the buyer, that is situation 1, and in situation 2 when the goods are not handed over to the buyer. Let us assume when the goods are handed over to the buyer. When the goods are in the possession of the buyer, seller cannot exercise powers straight away to take the possession of the goods directly, because the goods are handed over to the buyer. When the property in the goods has passed to the buyer, the rights of unpaid seller are different. When the property in goods has not been passed to the buyer, the rights of the unpaid seller are different. Let us assume a situation where the property in goods has passed. He has different types of rights, that is right of lien, right of stoppage of goods in transit, and right of resale. These rights of unpaid seller do not depend upon any agreement, whether it is expressed or implied between the buyer and seller, but they are given by the law. They arise due to the implications of the law. And assume a situation where the property in goods has not passed, the goods are still with the seller only. In this situation, the seller is in a strong and advantageous position. So, what he can do is he can withhold the delivery of the goods. Instead of giving the goods to the buyer, he can stop the goods from giving away to the buyer. When the property in goods has not passed to the buyer, the seller has got many remedies. But when the property in goods has passed to the buyer, the seller has got limited remedies. So this is the different type of rights available to unpaid seller against the goods. Now let us move on to rights of an unpaid seller against the buyer personally. Can a unpaid seller go against the buyer personally for any damages or price? Yes, he can go. He can move against the buyer personally to the court in order to sue for the price according to the contract made between the buyer and seller, and he can sue for damages for non-compliance or for breach of contract, and he can sometimes sue for interest also, because the loss suffered due to the breach of contract has led to some financial loss also. So in this case, the seller can move to the court for suing the buyer for interest portion also. Now let us see the rights of an unpaid seller against the goods in detail. As discussed earlier, the rights of unpaid seller against the goods are four types. These are right of lien, then right of stoppage in transit, and right of resale. So these three types of rights that an unpaid seller has against the goods. The first and foremost right is right of lien. Lien is nothing but the right to retain the possession of the goods until the payment in respect of the goods is received. Section 47 of 1 of Indian Contract Act describes the circumstances in which an unpaid seller may exercise his right of lien against the goods. Therefore, the unpaid seller who is in possession of them can retain possession until the payment or tender of the price is received. There may be certain conditions to this. There may be certain stipulations to this. First one, a situation where the goods have been sold without any stipulation as to credit. Second one, where the goods have been sold on credit but the term of credit has expired. The due time given for extending the credit has expired. In this case also, the right of lien can be exercised. And third one, where the buyer becomes insolvent. Where the buyer becomes insolvent, it is clear. It is very clearly understood that he is not in a position to pay the amount. Then in such a case, buyer will not think of giving the possession of the goods. Otherwise, he will retain the goods with him. It is important to note that the right of lien is linked with possession and not with title. Title may be transferred, however, title may be awarded. But here, the rule is understood in terms of possession of the goods but not the title of the goods. It is essentially a right over the property of another person. The unpaid seller's lien can be exercised only so long as the goods are in the actual possession of the seller or his agent. If the goods are not in actual possession of the seller or his agent, this right of lien cannot be exercised. Once the possession is lost, let us assume, the possession is lost. Once the possession is lost, the lien is also lost, because lien talks about only possession but not title. When the possession is lost by the seller or his agent, the right of exercising lien is also lost. He cannot exercise any right for taking lien. Therefore, the right of lien cannot be exercised when the goods are not in possession of the unpaid seller. And in some cases, if some credit terms have been accepted for the purpose of exchange of goods, for the purpose of selling of goods, here, when the term expires, the unpaid seller may exercise the right of lien, but not before the expiry of the term of credit. If term of credit is 30 days, he can exercise the right of lien only after the expiry of the period, that is 30 days. If the term of lien is given as 60 days, he can exercise the right of lien only after 60 days but not before that. Therefore, the lien of the unpaid seller is for the price only. This is an important point. The lien of the unpaid seller is for the price only. So, when the price has been paid, he cannot retain the possession of the goods anymore or for any longer period. He has to simply hand over the goods since the total price has been received. And in case some portion of the price is due, then he can retain the possession of the goods. And it is worth mentioning that right of lien is indivisible in nature, and the buyer is not entitled to claim delivery of the portion of goods on payment of a proportionate price. Further, this right is available even after part delivery of the goods has been made, unless such part delivery is made under such circumstances as to show an agreement to waive the lien. Therefore, in some situations, the waiver of lien may happen, and the situation is called termination of lien. The right of lien is linked with the possession of the goods, and this right is lost if the possession is lost, as discussed earlier. Once the possession is lost, the right of lien is also lost. Hence, unpaid seller loses his right once the possession is lost, and he may lose the possession in the following cases. In various cases, the right of lien is terminated. For example, by delivery to carrier. Delivery of goods to a carrier for the purpose of transmission from one end to other end, that is from the seller to buyer, is itself a direction to hand over the goods to the buyer, and the person who has assumed the responsibility of handing over the goods to the buyer, that is the carrier, will take the goods in his possession. Therefore, the right of lien of the seller is lost, since the goods are not in his possession. But the seller still has a right of stoppages transit. Before the actual delivery of the goods or before the goods have reached the buyer, the seller can, however, stop the goods in transit. The delivery to the carrier puts an end to the right of lien. Here, the position of the unpaid seller becomes weak. But if the seller regains the possession of the goods from the carrier by exercising the right of stoppage in transit, his lien revives. Again, he is in a position to take back the goods with him. He can withhold the transit and he can recover the goods from the carrier and he can put the goods in his possession and he can claim himself as an unpaid seller. But if the seller takes back the goods from the carrier for any other purpose, the right of lien does not revive. The main reason here shall be the payment. If the payment is not received in full, then he can claim himself as an unpaid seller and he can take the goods back that are in transit, but not for any other reason. If for any other reason he takes the goods back, then he cannot claim as an unpaid seller and his lien is also not revived. Then one more condition in which a lien is terminated is by delivery to the buyer himself. The right of lien is also lost when the goods are delivered to the buyer or his agent. When the seller has given the buyer possession under the contract of sale, all his rights in the goods are completely done. When the goods are delivered back to the seller for a specific purpose, such as repairs or maintenance or overhauling, that does not revive the seller's right of lien. It is only for a specific purpose, such as repairs or such as any other work-like servicing or general checkup. Then in such a case, the seller cannot revive his lien since the goods are handed over to the buyer. But in some cases, the seller's lien is not defeated when the buyer has obtained the possession without the consent of the seller. That is, without the consent of the seller by some mischief or wrongful act. The buyer shall have to take the possession lawfully under the terms of the contract that have they signed. They have to refer the contract, the agreements that they have made, and they have to see that according to the terms of contract what is the actual position. So on total, it can be understood that by delivery of goods to the buyer, the right of lien is terminated. Then we have one more thing, that is by waiver. By waiver also, the lien is terminated. Where the seller has waived the right of lien, which may be either in the form of an express or implied, the right of lien is terminated. A waiver is expressed where the contract itself provides that the seller shall not be entitled to retain possession of the goods even if the buyer does not pay the price. And a waiver is implied where the seller sells the goods on credit and grants a fresh credit terms. So this is important. After the expiry of the credit period, if the seller again grants one more credit term, he agrees to take the amount at a later date by giving a special credit period. Let us assume the credit of 90 days is given and again it is extended for one more 90 days. Then in such a case, the lien is terminated because the credit is extended from 90 days to 180 days. Therefore, here the lien is terminated. And one more reason in which a lien is terminated is by tender of price. Where the buyer tenders a price for the goods purchased by him. The seller no more remains an unpaid seller. Therefore, the right of lien is also lost. Here, the transaction is complete since the seller has received the price. For example, if rupees 10,000 is due on one particular good, if rupees 10,000 is paid by the buyer, then the lien is automatically terminated because the amount has been received by the seller and the seller is no more an unpaid seller. Therefore, right of lien is terminated in four ways: by delivery to carrier, by delivery to buyer, by waiver, by tender of price. Then we have one more right, that is right of stoppage in transit. Right of stoppage in transit. Transit means an arrangement between the seller and the carrier which ensures the mobility of goods from the seller's place to buyer's place. But the right of stoppage means the right to stop further transit of goods and to resume the possession thereof and to retain the same, that is the goods, till the price is paid. This is possible from the seller's end because it is the seller who has consigned the goods in transit in order to reach the buyer's place. But in the meanwhile, if something happens and the seller feels that he is unpaid and the goods have to be possessed back, then he can exercise the right of stoppage of goods in transit. The right can be exercised under a few circumstances. Let us learn what are those circumstances wherein the right of stoppage in transit can be exercised by the seller. First one, the seller should have been unpaid. That is, he must be an unpaid seller. Then second one, the seller must have parted with the possession of goods and the buyer must not have acquired it. This is most important, where the goods have been dispatched from the seller's end or seller's place but should not have reached or taken by the buyer. That is, the delivery of goods shall not be or should not have been complete to the buyer. Once the buyer receives the goods, it is the buyer who will take the goods in possession and he is the owner of it. If the goods which are intended to stop are stopped in transit, then it is called right of stoppage in transit. Therefore, the important condition here is the goods must not have reached the buyer or the possession of goods must not have been taken by the buyer. Then one more condition here is the buyer must be insolvent. He should have become insolvent. Insolvency is a position wherein the buyer himself is not in a position to pay his dues. Then in such a case, the seller expects that he will not recover the amount from the buyer. Therefore, the buyer's insolvency will help the seller to stop the goods in transit. And one more condition that is to be fulfilled here is the property must have passed from the seller to the buyer. Here the property must have been passed from the seller to the buyer. That is, we talk about title here. The title should have been passed from the seller to the buyer. The right of stoppage in transit arises only after the seller has parted with the possession of the goods and the buyer has become insolvent. The first condition is the buyer should have parted the goods, or the possession of the goods shall not be with the buyer. Then only the question of right of stoppage in transit arises. If the buyer has not parted with the goods, then the question of right of stoppage in transit does not arise. Therefore, the right of stoppage in transit arises only after the seller has parted with the possession of the goods. And this right is only available when the goods are in neither possession of the seller and nor in the possession of the buyer. The seller, after dispatch of the goods, should have been dispatched the goods, and the seller should not have received the goods. In this situation, it becomes important for us to know what is the duration of transit, because duration of transit can be small, duration of transit can be big, and duration of transit can be enough big that it may take some number of days and months also. Sometimes it may happen. Therefore, the right of stoppage in transit can be exercised only when the goods are in transit. Otherwise, when the goods are not in transit, the right or the question of stopping the goods itself does not arise. Therefore, the duration of the transit is of great importance in this case. And goods are deemed to be in transit from the time they are delivered to the carrier, that is sometimes we call him as Bailey, for the purpose of transmission to the buyer, that is the destination, until the buyer or his agent takes the delivery of the goods after the goods reach. Therefore, much depends upon the time and much depends upon the transit to say whether a right of stoppage in transit can be exercised or not. Now, what is the position of the person who has taken the goods in possession for transit? That is the carrier. Who is a carrier here? Whether he is a seller's agent, whether he is a buyer's agent, or he is a third party, that is an independent person. Sometimes it may happen that seller may have his own agent as a carrier. Sometimes it may happen that the buyer may have his own agent as a carrier. And sometimes it may happen both of them arrange an independent person as a carrier. The position of carrier or bailee is important to stop the goods in transit. In the first case, if the bailee is a seller's agent, then there is no transit because the goods are under the seller's lien, even now also, because the carrier is a seller's agent. If the carrier is a buyer's agent, then the situation is different. In this case, the seller cannot exercise his right of stoppage in transit because the buyer has acquired the position through his agent, because the person, the carrier, is the buyer's agent. Situation differs when the carrier is buyer's agent and when the carrier is seller's agent. Then if the carrier is an independent person, then if the carrier is an independent person, the seller can exercise the right of stoppage in transit. And it is not essential or compulsory that the goods shall be moving. Just handing over of the goods for transit is essential or necessary for stopping the goods in transit. And once the goods start moving, the transit comes to an end in some cases. If the buyer or his agent obtains the delivery of the goods, then the transit comes to an end. Or when the goods arrive the destination place and the transit is over, then in such a case the transit comes to an end. Therefore, the transit comes to an end when the buyer takes the goods in his possession or his agent takes the goods in his possession, or the arrival of goods at the decided destination. Then in such a case, the transit comes to an end. But sometimes it may happen that the goods are rejected by the buyer or refused for acceptance by the buyer. In such case, the transit does not come to an end. The transit does not come to an end if the goods are rejected by the buyer and the carrier or the bailee continues the possession of the goods. So therefore, in this case only on rejection, the goods are still in transit. Now, how the right of stoppage in transit is exercised? He can exercise the right by actually taking possession of the goods or sometimes by giving a notice of his claim to the carrier or other bailee in whose possession the goods are, and such a notice is enough to stop the goods in transit. Now we have one more right of an unpaid seller against the goods, that is right of resale. In some situations, it happens that a, an unpaid seller will go for selling again the goods, that is exercising his right of resale because he has not received the full amount from the buyer. So in such a case, what happens is resale of goods is continued by by following the terms of the contract, and this right is a limited right as conferred according to section 54 of the contract act, and it is exercised only in few cases, only in few cases where the goods are of perishable nature. Goods are of perishable nature and have got limited life. For example, milk, vegetables, and fruits, which have a perishable nature and a limited life. In such case, what happens is when the buyer does not turn up, when the buyer is not responding to the seller's request, then in such a case he can go for a resale because the goods are of perishable nature. And in this case, the unpaid seller need not give a notice to the buyer of his intention to resell the goods again to some other person. As the buyer is aware about the nature of the goods and terms of the contract, the seller need not inform him or need not give notice to him again mentioning the resale of the goods. And where the unpaid seller has exercised his right of lien or stoppage in transit, he can give notice to the buyer regarding his intention to resell the goods again. And if the buyer does not respond within a reasonable time, then the seller can resell the goods. And in some cases, he can recover the loss that has occurred in this period from the original buyer also. And the seller is entitled to earn the profits also in this case, in case of resale. If there is a price difference between the agreement made with the original buyer and the alternate buyer who has arrived in resale, then the seller is entitled to earn some profits also. He can earn some profits also. And in some cases, in some agreements, it may happen that the seller expressly reserves a right of resale according to the contract that they make. And in case the buyer makes default on accepting the goods, the seller can go for resale. So in these cases, right of resale is also exercised by the unpaid seller apart from the other rights, that is right of lien and right of stoppage in transit. So apart from this, we have one more thing, that is rights of unpaid seller against the buyer personally. So against the buyer personally, the unpaid seller can go for suit for price, can go for suit for damages for non-acceptance of goods, and suit for interest. All these rights he can take by approaching the appropriate authorities. That is, uh, when the buyer refuses to accept the terms of the contract, then he can move to the court for claiming a price, for claiming damages, and for claiming interest also. So for claiming price, he can go for a suit for price wherein under a contract of sale, the property and goods has passed to the buyer and goods have actually come into his possession. The unpaid seller's only remedy is a suit for the price. Since the goods are in the possession of the buyer, he cannot go for taking back the possession of the goods, but he can provide or he can put a suit for the price. And in some cases, he can go for suit for damage of non-acceptance, where the buyer willfully or wrongfully neglects and refuses to accept the goods and pay the price for the goods. The seller may sue him for damage of non-acceptance because he has suffered some loss due to non-acceptance of the goods that have been agreed upon between them. Therefore, in this case also, Section 73 and 74 of Indian Contract Act lay down some provisions for the damages that can be paid for non-acceptance of the goods. And sometimes it may happen that the unpaid seller can go for suit for interest also. Sometimes it is possible that he can go for providing a suit for claiming interest in the court of law out of the contract. When the buyer willfully refuses to take the possession of the goods, the court may award interest on the price from the date of the tender of goods and when the price is payable. If the goods are sold on credit, interest will run from the expiry of the credit of the credit period of the contract given. Therefore, it is important that rights of an unpaid seller can go against the buyer personally also in case of refusal or non-compliance of the contract. And it is important to learn that rate of interest to be awarded is at the discretion of the court. The court may fix the rate of interest that can be paid by the buyer to an unpaid seller, and it can be noted that seller can only recover interest when he is in a position to recover the price. When he is in a position to recover the price, only interest portion can be claimed. But when he is not in a position to recover both, he can recover both. When he can only sue for damages for breach of contract, he is not entitled for interest. When damages are claimed, he cannot go for interest. Now let us move on and see what are the consequences of breach of a contract of sale. Consequences of breach of a contract of sale are treated normally according to the breach of contract of sale. In case of breach of contract of sale, consequences are faced by both parties. That is, the buyer will be facing some consequences and the seller will also be facing some consequences. But the law provides a remedy to both. Law provides a remedy to both, and there are some remedies to the seller and there are some remedies given to the buyer also. If there is a breach of contract on either side, sometimes there may be a breach of contract from the buyer's side and sometimes there may be a breach of contract from the seller's side. Then in such a case, what happens? Let us see. In case of breach of contract, seller has got some remedies like suit for price. He can go to the court of law claiming for price. Then he can go for damages for non-acceptance of the goods by the buyer. Then he can go for suit for interest. Then he can go for suit for damages of repudiation of contract by the buyer. These have been already discussed earlier. Now we can have some remedies to the buyer also. A buyer has also got some remedies. Those are suit for damages for non-delivery of the goods. When buyer is at no fault and he has completed all the formalities of the contract, then buyer can also go by filing a suit against the seller for damages for non-delivery of goods. Then suit for specific performance. He can demand for specific performance also. Then suit for breach of warranty also. In some cases, if some warranty is extended by the seller and if the warranty contract is not followed, if the warranty contract is not respected, then he can go for filing a suit against the breach of warranty also. Then he can file a suit for damages of repudiation of the contract also by the seller before the due date. If the seller repudiates the contract before the due date also, then he can go for filing a suit for damages. Then finally he can go for filing a suit for interest also, because the loss that he has suffered due to non-response of the seller, he can go for filing a suit for claiming the interest amount from the seller also. Thank you.